Chris.
Yeah, okay, we'll do a roll in just a minute. Okay, we're good. So it looks like we have folks here. We're now recording. Welcome. This is a work session of the Anchorage Assembly on AO 2023-107, amending AMC section 25.30.020 regarding land disposals. So I do not know who is prepared to present the bones of this one. So Meg, do you want to start?
Do you want me to
After
do roll?
you do roll call, I will.
Oh, I'm sorry. Madam Clerk, you have the floor.
Member Myers? He's not here yet. Member Martinez?
He is. It looks. Oh no, he's
Right.
invited. Go ahead.
Member
Go ahead.
Martinez is here. Member Rivera?
Present.
Member Bronca? I am not hearing from Member Bronca and I don't see on the list. Member Johnson? Is not here yet. Member Constant is here. Member Zalatel is here. Member Cross
Here.
is here. Member Volland? Do not see him in the list. Member Brawley?
Here.
Member Stoltz? Is
Here.
here. And Member Presverdia? I do not see his name in the list. There you go.
All right, Ms. Zalatel.
Thank you. So I don't think it's any surprise to see this ordinance 107. It really closes the donut hole of the conversation we had on Tuesday night around operating agreements, or these agreements that really have lease-like qualities but aren't technically leases. I think what we've seen kind of as we've evolved as a municipality is that we have more and more tools in our toolbox, and sometimes code doesn't keep pace with those tools in the toolbox. However, at the heart of an operating agreement or these hybrid agreements is the disposal of an interest of municipal property, or a value-based disposal, and those do require a public hearing and vote by the assembly. So these code changes make that very clear. I had the pleasure of working on this with former municipal attorney Dee Ennis, along with Assembly Council and Legislative Council. And we've really kind of looked at a variety of permutations about how to go about doing this. And I think this is just a really simplistic, clean way to make sure code keeps up with the practices that are being utilized within the municipality. So that's my introduction. We could go one of two ways, Chair. We could have council walk through the ordinance. However, I do think it's really straightforward. We could jump right into member questions. And then I do understand that there had been some proposed changes potentially coming from the administration. I was told I would be getting written correspondence of those, so I would be able to address them today, but I hadn't yet received those. But I do see a number of individuals from the administration on the line. Thank you.
Thank you. No, Mr. Myers has joined us at this time. So really the question, do we want to walk through the ordinance briefly? And if so, can the clerk call it up?
Sure. It'll take me a second to get there.
Thanks. And like Mr. Cross in the previous work session, my power has flickered a couple of times. And so if I disappear, then Ms. Zalatel will have the floor to manage the meeting.
Chris, there's a hand up from.
I see Ms. Alger, but currently I have Ms. Zalatel and we're putting up the item to go ahead and briefly walk through it.
Can you see it?
Yep,
Yes.
I can. Can you go ahead and scroll down? The meat of it is not at the beginning. And And so it really is to deal with any conveyance. Yep, right there. There's the meat. Subsection D, conveyance, disposal, or contract or other agreement that transfers or conveys substantial or total control over the operation or use of municipal property or facility shall be treated as a disposal. And then what it does is it excludes the following. And so it walks through specific exceptions to that. Note number 4, D4, that exception. So we have been talking a lot about operating agreements, but where operating agreements and similar agreements, to the extent that they were already competitively procured under Title VII and subject to assembly approval under Title VII, both of these things get you to the same place. And so this isn't an additional process. This is saying the core of this is there needs to be notice, public hearing, and approval. And then subsequent material amendments to the scope, terms, or control of the disposal also require approval of an ordinance. So, you know, that really goes kind of back to the heart of what we took up in that prior agreement. The adding a facility as a substantial amendment wouldn't get you out of it would still require and trigger the public hearing and approval process. So really, it's important to, or if there had been a change in the material conditions around when we, the municipality might be liable for payment, or if we had additional considerable financial costs associated with an agreement pursuant to an amendment. So as I said, the change in the ordinance is in and of itself not terribly complex, but I think it really closes this donut hole we have in code that doesn't align with a variety of tools we are using in the municipality. With that, I'll turn back over to you, Chair.
All right, thank you. So this was underway long before the conversation that happened on Tuesday night, but it certainly is informed by that whole discussion. So Ms. Alger, you were in the queue. I don't see you there now.
Thank you, Chair. I just wanted to state that my internet is coming and going, and if you guys lose me, I'll hop back on just as quickly as I resume service.
Thank you. So do any members have questions so far about the proposed change? Oh, note that I'm just adding Ms. Bronga to the meeting. Welcome. So any members have questions? Okay, so I don't
Mr.
see.
Chair,
Go
I had a
ahead.
question. This is Ann.
Yeah, okay, go ahead. There we go. Now I can see there. Go ahead.
Yeah, thank you. I just had a question. So, so I understand we had that big discussion on Tuesday. I was wondering if someone could give a couple other examples of, you know, current operational agreements or ones that have happened in the past, just kind of the types of facilities or uses that we're talking about.
Well, there's one specific one that raised some substantial concerns in the past, which is where this project really began. And it was the WICA user agreement that allowed a private corporation to take over use of the Golden Lion facility to provide what they received as free medical treatments. And they sold them to the public, and we paid for all of their utilities and lights and everything so they could run this very lucrative endeavor. And we never saw anything about it. We never had authority, but that Golden Lion was put into use without authority. So, but really specifically to your question, I have put in a records request, a formal records request under the municipal code and the state law to the Department of Law for a comprehensive list of all of these use agreements over the past 10 years so that we can inspect in detail the ways it has been used. That's probably the best example I have. Mr. Bowman has his hand up.
Through the chair to, I believe, Assemblymember Brawley. I think I can give additional examples in addition to what the chair has already talked about. We also have operating agreements for the PAC, for the Egan, the Denina. There is a lease with many operational It's an operating agreement that falls closer to a lease for the golf course and for the museum. We're in receipt, laws in receipt of the record request from the chair, and we don't have those records. I'm happy to help track these things down for obviously for the chair per his request, but if other members of the body would like to see those, we can get the agreements that I've just described out the door relatively quickly. I think there might be some other operating agreement type things that have been done through parks. It'll take a little longer to dig those up, but we'd be happy to share those with the body once I'm able to find them. It's just records that law doesn't have their immediate fingers on. And we're having to go back farther than 10 years because most of these agreements have very long durations that are older than that. But I think it's totally within the ambit of the body to take a look at those and think about those. So happy to share this with the body, but that's a few examples of facilities and types of projects and agreements that fall into this.
Right, and just a matter of housekeeping for the purposes of getting into the queue, please put in the chat that you would like in the queue. Raising hands is hard for me to track who was in there in what time. And so also note that the chat is not to be used for the purposes of deliberations. It should really just be housekeeping. I would like to speak. You missed me. Can we return to the previous item? Not anything substantive because the chat is not part of the public record. After the meeting is adjourned, it's not being recorded. And so with that, I have Ms. Zalatel first.
Thank you, Mr. Chair. I believe Dee Ennis, who has assisted with this, is on, and I would like if she could speak kind of to Ms. Brawley's question and where, basically when we should be contemplating the change here based on this ordinance, what types of things we could be expecting to see beyond just the example that we've seen recently.
Can you hear me?
Yes.
Yep. Okay. Almost all our bigger facilities have some form of an operating agreement, whether there's elements of a lease or not. So historically, you look around, all our bigger facilities have that. Issue didn't come up because they were coming through as operating agreements, lots of public process. Going forward, I think new agreements, it just gives everybody warning, either Title 7 or 25. These deserve public process. They're significant assets. However, I don't see retroactive application to any of our current facilities because it's really the application is assembly process, and almost all of them, I would bet all of them had this type of process.
The retroactive look wasn't for the purpose of applying this law to them in reverse. It was simply so that we can all understand the nature and scope of the use of these agreements over time and what's in the contents of them. So, but thank you. So that was a good summary. Meg, did you get your question answered? Is there any more detail you'd like from Ms. Ennis?
No, not right now. Thank you. And thank you for being on, Ms. Ennis.
So I did see before that Ms. Halser had her hand up, but did not put herself in the chat. Ms. Halser.
Hi, everybody. Thanks, Chris. I just wanted to clarify some of the things that Ben said, and certainly we did get your records request and we looked into it, and as I understand, there was only one operating agreement that was within 10 years that we had, and Ben can correct me if I'm wrong, and that the ones that we were going to send over to you are actually longer than 10 years ago, and that the reason for that is because these are very, very long-term contracts. And so I just wanted to clarify what Ben was saying. And unfortunately, Ben and I are not in the same room. And so if he could just clarify that, I wanted to make sure that there was no misunderstanding that this is a practice that happens very, very regularly. These are unusual agreements. And the one that we found was one, and it was I believe it was 10 years old. So I just wanted to make sure we had clarified that.
Great. So I think probably what I'll need to do is clarify the request, because I'm aware of several of these agreements that have been signed and reviewed by law because I received them from municipal attorneys previously. And so maybe the nature and scope of that request was too specific, because it's not just operating agreements, it's use agreements that are time specific and more than 90 days. So I don't know if Mr. Bowman wants to add anything to that, but if not, Ms. Zalatil has herself in the queue again.
The only thing I'd add, Chair, is I'm happy to work with you on fulfilling your request.
Ms. Zalatil.
Thank you, Mr. Chair. What I want to point out about this language as well is it gets us out of, it's drafted in such a way as it doesn't matter what the title of the agreement is, because I think we got into a bit of a set of semantics, and we can, right? I mean, a contract, it's more about what it does versus what it's called. And I think that that's really important because nomenclature changes over time. Ultimately, these are contracts with certain characteristics, and so it's drafted in that way to really hopefully withstand the test of time, and so that the code can keep up with whatever the current format or standard is, and it takes into account when there might be those anomalous situations where it truly is this kind of hybrid agreement that would have found the donut hole in code, where we would want to know about it because it is meeting one of these requirements, is turning over total control or operation of like major municipal assets. And I think that that's the beauty of how this has been drafted, is it's more about what it does and what triggers it. And that at the heart of that are two things. One, there's substantial public interest in, that taxpayer dollars or bonds pay for these things, and two, that they should get the opportunity to weigh in on these municipal assets and how they're going to be used. And then then we're able to take that consideration in, because obviously that isn't an option when it's a contract or a negotiation between two parties. We don't ask the public to weigh in into that process.
So in the chat, Ms. Halser put, I think this is about whether it is a transfer of property interest, real property. And so the chat is not the proper place to put things of that nature. It really has to be on the record. But having just read that, I would say it is, and that's fine. Other members, Ms. Brawley.
Yeah, thank you. I think this is a legal question, just understanding the difference from what Ms. Hauser said about a transfer of property interest. A lease is it's basically exclusive use, right? So if an operating agreement is also essentially exclusive use, I imagine you can't have a second concessionaire, for example, in a public facility. Then I guess I'm still not really understanding the difference between those things.
Would you like me to respond? This is Dee.
Sure, Miss Ennis, go ahead. I'm sorry.
I'm sorry. I was going to say, Ms. Brawley, I'm not sure there is much of a difference, and that's the conundrum here, is there isn't much of a difference. Just as you said, a concessionaire, not anybody can go into the Sullivan Arena. And there are some comments, well, the municipality can go in there and do some repairs or something. That's still not, this is a transfer of an interest. And I go back to sort of the common sense of the charter. If you're conveying something big, and by the way, there's land or improvements. It's not just land, it's improvements on it. I mean, it captures small things like easements, right-of-ways that are so much smaller than what happened here or any large, that I'm not sure that distinction matters at all. And to find a document and say, well, this has 4 characteristics of a lease, this only has 2. And as Ms. Zalatil suggested, this ordinance avoids that kind of naming of ordinances.
And naming of tools.
Yeah.
Contracts. So
and can I add one thing, Chris?
Yep, please.
The other thing I hear batted around quite a bit is this concept of exclusive use. And we purposely avoided that here because that's just another problem that will create issues in the future. So it is substantial. And I mean, I think a lot of these are just very obvious what we're talking about. Going back to the intent of the charter.
Yeah, and I will add, oh, I see a number of people in the queue. Okay, I'll put myself in the queue so I'm not out of line. Are you finished there, Dee?
Yes,
Okay, stick around. Ms. Brawley.
Yeah, I just wanted to mention, again, not an attorney, but I remember a conversation about use of alcohol licenses that people were doing things like management agreements and basically trying to skirt the idea of who's responsible for the license and all of those things. So I just wanted to flag that. I don't know if that's an analogous situation, not to change this ordinance, but I know that's come up in the context of licensing too.
All right, Mr. Bowman and then Mr. Gates.
Just to clarify, the administration and the law department took, I'm speaking broadly, but my understanding from the administration, and hopefully someone will correct me if they disagree with what I'm saying, but is not opposed to this language, thinks it does a good job of, to use Meg's term, closing the donut hole, and is well drafted and elegant. So we're hoping it'll stand the test of time, like Meg said, and we think it will, and that this looks good. So just to clarify, administration is in support, to my knowledge.
Mr. Gates.
Thank you. And let me know if you have any trouble hearing me. So I just wanted to add to Ms. Ennis's response to Member Brawley's question. And I wanted to maybe help clarify more by using an analogy that law school professors often use about property. And so real property, you have a fee simple interest. These are municipal lands, the municipality owns them outright. These facilities are properties. And in law professors would say when you have a fee simple interest, you have a bundle of sticks. That's the whole property interests. And what this does is, well, if you hand over some of these bundle of sticks to another party by whatever instrument, a use agreement, operation agreement, you're handing over a substantial amount of these bundle of sticks of property rights, maybe not all of them. And this is trying to capture where you hand over so many of these sticks that it's substantial control of the operation or use. You can't get them back for a definite period of time, and that's what we see happening. And that's why we think those should go, I guess, as interest in municipal lands for an ordinance for approval and with the whole public process, you know, because that's really, well, handing over a significant portion of your stakes to someone before you can get it back for whole property interests. So I hope that helps understand a little bit.
All right, so anyone else at this time? Sounds like at this time there is no contention, and it's hoped that this goes a long way to resolve some of the tensions that were discussed at length last week or 2 days ago this week. And if there's nothing further, then we will adjourn. Wait, Ms. Helzer, really what I need is for you to put yourself in the chat so I can see that your hand is up, but you may have the floor at this time.
My apologies for that. I'm working from my phone on here and I'm not totally accustomed to this phone and being on Teams. So
Yep.
I just wanted to say that I agree with Ben and Dean and that this is a very appropriate ordinance. What it does is it closes that gap that we referred to the other day at the meeting, and makes everything more consistent. And so I want to reiterate that there, you know, a lease is quite a different thing than an operating agreement. And so I also want to make that clear. And even if something has provisions that are typically in a lease or another type of contract, it doesn't make it a lease or a different type of contract. And of course, Ms. Altel is correct too, in the sense that if something is named a, you know, operating agreement, but has, you know, is otherwise contains all the terms and provisions of a lease, it can't be an operating agreement. And just for clarity, this past Tuesday, that was not the case. There was very distinct reasons that this was an operating agreement and not a lease. And so I just wanted to make sure that was clear. And that's all I have to
interrupt
for
and,
today.
and say that then it sounds like your interpretation of this ordinance is that it wouldn't have affected what happened at our last meeting, and that you may continue to support the granting of a significant use of one of those sticks that Mr. Gates referred to simply by the definition that you just gave. And so, Dean, I'm going to ask that you draft up for the record when we have this deliberation exactly kind of that metaphor you just used, so that the record is pristinely clear that we don't care if you call it a lease or not. It's if you are disposing temporarily more than 90 days the use of a property of the municipality, that then it is subject to this section of the code. Even if it's only partial. And the reason we went with 90 days is that parks, for example, rent out the use of a park facility for a day or a week, depending on the big events. We don't want to get to that level of business. That is not the purpose here. The purpose here is when a municipal property is put into a significant control of a third party, then the assembly should know. So anyone else? Oh, wait, there's Chad. Ms. Zalatel.
Yeah, I just wanted to say in closing, I think that it's really important, especially since the body is primarily not lawyers, which has been a shift. I am the only one that we really have code that gets beyond technical legal distinctions and makes it very clear, not only to members when a public hearing and approval is required, but puts the public on notice in what I think is fairly plain language about when this two-step process will be required, so that they are well aware of what to expect when engaging in or doing business with the municipality when it falls under these terms. And that really takes away that awkward position we were in Tuesday where, you kind of have an operator sitting there shocked and a little bit surprised to be at an assembly meeting. This puts everyone on notice that this is the steps. These are the steps in order to effectuate whatever agreement is reached, on, as long as it has these characteristics. So I think this is much clearer to the public and much more transparent. Thank you.
All right, I'm not seeing anyone else in the queue. I think for that, these scheduled meetings are scheduled to a ceiling, not a target. The Dunbar principle, we can adjourn early, and we will reconvene at 2 for the next work session. Thank you, everybody.